wanted you to see that.
Good afternoon and welcome to the afternoon session of the June session of the Tennessee Court of Criminal Appeals here in Jackson, Tennessee for the Western Section. We're delighted to have you today. Protocols have somewhat changed and we sort of doing things a little bit different. We appreciate your accommodations. We appreciate your suggestions and we appreciate you bearing with us during these particular times. We have tried to make the Tennessee Court of Criminal Appeals as open as we possibly can. We've done that in 3 different ways. One, if you wish to see us, please come by and we will welcome you in the courtroom. If you are interested or even curious as to what we do and how we do it, we would love to have you. You can contact the clerk's office and make any arrangements that would be necessary if you think there's some extra special circumstances you may have. The second way you can access the processes of the Tennessee Court of Criminal Appeals is log on this afternoon to YouTube. View us live as we proceed and hear the arguments. A third way, in case you do not have access to a computer, is we will provide you a telephone number you can call and listen to the arguments live and in real time there. Today, I'm honored to have with me from Memphis, Tennessee, to my left, Judge Ross Dyer, and from Memphis, Tennessee, to my right, and my right-hand person, Judge Camille McMullen. I'm John Everett Williams from up the road here in Huntington, Tennessee. Each side is given 20 minutes. If you wish any rebuttal from the appellate side, please do so upon your introduction to us. You may stand or sit. You may use your mask or not if you wish to argue. I hope you can hear me well. If you cannot, please give me an eye sign. I'll remove my mask and maybe it'll be clearer. I will do the same for you. I will try to help keep up with your time as well. Mr. Clerk, would you please call the first case?
State of Tennessee versus Antonio Toomes.
Good afternoon. May it please the court, as a preliminary matter, before we begin, may I make a couple of introductions to the
Sure.
court? Behind me is Mr. Glover Wright, who is a lawyer in the Public Defender's Office in Shelby County. He is born and raised in Trenton, not far from here in Gibson County. Humboldt. Excuse me. Big
Even
state.
closer.
Big. I studied law at Columbia University in New York City and is with us, I think, on video. But he is an excellent trial lawyer and has been for years. They're restructuring their office a bit to allow people to defend cases all the way up now into the appellate courts, and he will be making his first appearance in about 10 days before this court, and wanted to come see how it works today.
You have a good mentor, and welcome.
Thank you for having me.
Mr. Working, can you give us his name again?
Glover Wright.
Glover.
We also have with us today Janet Good. who is someone who worked on this brief a tremendous amount with me. Miss Good is a graduate of Stanford University in California and a former law professor both at University of Memphis and at University of Michigan. She's also my neighbor. We both can walk to work and have lunch together. And this is her first appearance today.
But welcome.
Thank you.
Thank you for coming. Mr. Working, you're welcome to sit if you wish, or you may stand, whatever is comfortable. We found out, some of us that are a little grayer hair than yours, we found out that once we stood up and there was not a podium, our notes were too far away, so we sat back down. So you have it either way you wish it.
Well, creature of habit, Your Honor, I'll do my best to stand when I address the court. If it please the court, I'd like to go ahead and begin an oral argument.
Yes,
with
sir.
Mr. Toomes. I'd like to reserve 4 minutes of rebuttal also.
Yes, sir.
Mr. Toomes raised 3 arguments in his original appellate brief. I'm really going to focus on just one. That argument is the deprivation of counsel the day prior to his trial for first-degree murder. Mr. Toomes, I believe, fell victim to a total failure of the adversarial process. And it does not begin merely with Mr. Toombs's trial or the hearing the day before his trial, but months beforehand, according to the statement of Mr. Toombs' counsel. Mr. Toombs was originally appointed the public defender who chose not to be present, I believe, 3 times for his 4 interrogations by law enforcement. That lawyer created for herself a conflict of interest where she became a witness to suppression issues. She herself filed in writing, became a fact witness and was ethically barred from participating as Mr. Toombs' counsel. He was then appointed another counsel, private counsel. The case went on for about another year, and they had a disagreement about strategies in the case and how it should be defended. The trial court at that time replaced his private counsel with a 3rd counsel. There was no blame cast on Mr. Toombs. There were no aspersions from either way. They just had a disagreement. They weren't working well. They moved on.
There were 2 disciplinary complaints filed, though, were there not?
That's probably true. I believe it was exactly 2. And not to be glib to the court, but those happen constantly in defending criminal cases. I have never had the board of professional responsibility, but as someone who has won many first-degree murder trials, I have had more than I can count. I have never used that personally, a cap complaint, a letter, I want my lawyer to do something different. And I think that's part of the process about our job, frankly. It's not pleasant, but this is a stressful job. We have to make stressful decisions, and people disagree about how that should be done sometimes. It's always a tension with your client. I have never personally used that as a reason to withdraw from a case. And I don't say that Mr. Webb, who was attorney in this case, was wrong to do so, but they had a disagreement about the case. And at that time, the trial court cast no blame on either Mr. Toombs or Mr. Webb. It's something that's quite common.
Yes.
We move to the 3rd counsel. The 3rd counsel and Mr. Toombs had a lot of disagreements about how 3rd counsel was handling the case. Not communicating with his client, not filing motions, not preparing. It gives me no pleasure to say this, but the complaints that Mr. Toombs made are the same complaints that this court has made against that lawyer.
Is that in the record?
It is in the record. It's in the public record. I would ask you to take
That's
notes.
not why. Is it in the record in front of this court?
I don't know. I don't know. I don't know. And I don't know because Mr. Toombs, for years, filed so many motions that this is one of the most complex records I've ever seen. And both counsel here today had problems with that. I don't think that that's in. I know that Mr. Toombs said that several times in appearances orally. I don't know that he put those complaints in writing. But I believe that he may have said that on transcripts several times. I may have even said it myself at the motion for new trial, but I can't speak to what every word of the transcript is right now. However, counsel argued, the trial began on February 2nd, 2016. Counsel argued on January 11th that there was a problem and he should be relieved. Filed his own motion. It was denied. The trial court told counsel to prepare for trial, had another 3 weeks to go, and to work with his client. By counsel's own admission, by his sworn testimony, he failed to do so. But if I could just back up for a second. At the January 11th hearing, Mr. Toomes is de facto and probably legally without counsel. His counsel is adverse to him. And he has not appointed any sort of new counsel to protect his interests, that his counsel is advocating against him. And counsel loses.
When you say counsel is advocating, I mean,
That he should be allowed to withdraw.
well, the trial court denied that motion.
Correct.
So when you say he was effectively without counsel at that hearing, what do you mean?
I mean that the lawyer that day was arguing against protection of his own client's rights and asked to be relieved of responsibility to the court and to the client.
Well, I mean, how is that different than any other motion to withdraw by counsel? We don't appoint an attorney to be present with the defendant at every motion to withdraw by counsel hearing, do we?
No, but my argument today is ethically, we probably should. We should.
So every time, let's take it to this court, every time you file a motion to withdraw from a case after we issue an opinion, we should appoint a lawyer to your client at that point to let them review your motion and to see if your client wants to respond before we let you withdraw?
If you're speaking about Rule 14, I would say no, because you're not ethically obligated at that point. You can ask permission to withdraw, and that's what the rules allow for.
Well, the rules allow you to withdraw, to ask to withdraw if you're a trial counsel, do they not?
The rules do, but in this case, I'm saying that, in the weeks before a trial, it definitely, probably more than borders on unethical. But we'll take that to the next hearing. Take that to the next hearing. They appear again, and the defense lawyer has not worked on the case at all, despite the order of the trial court.
Well, I'm with you, Mr. Working, but you're leaving out some facts. He was getting phone calls threatening his life.
Actually, no. There was a phone call made in December.
And
There
the
was a
hearing,
phone call made in December from a person that everyone agrees, including the state and all the state's witnesses, everyone agrees is not Mr. Toomes. Now, even assuming, arguendo, that Mr. Toomes is part of this conspiracy to make the call happen.
and that was a finding by the trial court.
Sure, that happens in December. There's then a hearing in January, and the defense attorney loses that hearing.
Sure.
There are no new facts that are developed. There are no new phone calls made. In fact, there are no communications at all with Mr. Toomes, who is incarcerated because his lawyer does not follow the order of the trial court and says so the day before trial. He says, I have not talked to him. I am adverse to him. The judge asked, can you be ready for trial tomorrow? And he says, well, maybe I can be, but I wouldn't. I'm adverse to him. The lawyer did not work on the case.
Let me ask you this. Yeah, I want to be clear on facts. Okay. At the January 11th hearing, from your position, at that hearing, did the trial court apprise the defendant that if he persisted in his behavior, he would lose his right to have counsel?
I believe that is accurate. I believe that happened.
Where?
I believe that the judge said that in the January hearing, if you don't cooperate with your counsel, if bad behavior persists, I will strip your right to counsel. No behavior continues. There are no more phone calls. Even if Mr. Toomes did that, there's no more phone calls. There's no communication at all. Mr. Toomes is incarcerated and his lawyer does not visit him and communicate for the 60 days before the case. He does not visit him or communicate with Mr. Toomes even once from January 11th, when he's ordered by the court to do so, until he walks in to literally be an adverse witness against his client for the state's motion. It is a total failure of the adversarial process. And Mr. Toomes, it doesn't appear, has any idea if he's supposed to cross-examine witnesses or who is supposed to do that on his behalf while the state seeks to deprive him of the right to counsel. He is completely unrepresented before any decision is made that he should not be represented. He is deprived of counsel in the hearings to determine whether he should be deprived of counsel. And how does the state even have standing? I don't mean to be ridiculous, but it's ridiculous.
Well, standing may not be the right word, because standing is a legal concept that is really only appropriate in Fourth Amendment settings. This is not that. I understand your point.
I believe it is for simple due process. Imagine how much I would have been rebuked by this court if we started today by me filing a motion to determine who the state's counsel would be or whether they were allowed to have counsel. It's preposterous. I have no right to determine whether Ms. Decker is their representative today or whether they should be allowed.
Your position is the state was somehow barred from giving the trial court advisory memoranda on the situation in the case?
That's not what they did.
It's up to the trial court to make the determination of whether the individual either implicitly or explicitly waives his right to counsel, regardless of what the state does.
Well, the state definitely took a position and
Absolutely.
motioned the court to make their opponent much weaker on the eve of trial. And they cited the Carruthers case to do it, which is absolutely not parallel in any way to Mr. Toomes' position. Mr. Carruthers physically assaulted his lawyers, threatened their families, threatened their staff. He had 8 lawyers appointed to him, one twice, both as a mitigation specialist and a lawyer. He retained one. And even when the judge makes a finding that Mr. Carruthers has forfeited counsel, the trial court gives him copies of the rules of procedure, copies of the rules of evidence, and continues the case for like 4 months.
We continued the case because the state needed the case continued.
That helped. But it's not precedent for what happened to Mr. Toomes.
I'm just saying, I mean, Carruthers was continued because the state asked for a continuance, not because Carruthers asked for a continuance.
I agree that that's true.
Okay.
However, they didn't have to address the issue of whether or not to go forward on Mr. Carruthers because the state also asked for one. It should also be noted, the state never filed a motion to deprive Mr. Carruthers of counsel. In fact, repeatedly advocated that Mr. Carruthers should have counsel and expressed frustration without question, but said he should have counsel. It was a big capital case that the state wanted to stand up on appeal. And throughout the entire process, the state, represented by a very aggressive prosecutor, always advocated that Mr. Carruthers should have counsel. Mr. Toomes, every single time he's asked, says, I do want an attorney. I do not waive my right to attorney. I do not waive my right to attorney. I don't want this guy because he won't talk to me. He won't visit me. He won't do the things that you, the court, are telling him to do.
Well, let me ask you, because that's not how I read the briefs. And obviously, I've not read the record yet, but you just said that he repeatedly said, I do want an attorney.
Yes.
Were those questions actually asked of him at any of these hearings, or is that your characterization of the answers?
That's actually asked of him.
Okay.
He says that. He stands up and has discussions with the judge, the trial court. And even the state's brief, I believe, specifically acknowledges Mr. Toomes saying that. The state's brief says he forfeits the right to counsel, but he said that he wanted a lawyer.
He just didn't want the lawyer he had.
He did not want the lawyer who refused to follow the trial court's orders to communicate with his clients and prepare for trial.
You're getting into your rebuttal time now, Mr. Parker.
I'll save my time for rebuttal.
Thank you.
May it please the court, Catherine Decker representing the state of Tennessee. I'm also going to focus just on the issue of the waiver and forfeiture of counsel. First, I'm going to discuss what actually happened, and then I'm going to spend some time going down maybe 6 or 7 of the points that defense counsel has raised in his reply brief, and here that either 1, do not comport with the record, or 2, do not comport with the law. So what actually happened in this case that supports the trial court's decision that the defendant waived or forfeited his right to counsel is much evidence that was brought out of the February 1st hearing, that the defendant, with the obvious goal of delaying and disrupting the trial of the case, persistently sabotaged his relationship with 3 attorneys. He engaged in obstructionist behavior, repeatedly made unjustified accusations about his attorneys, repeatedly filed pro se motions as if he were in fact his own attorney, and asked the court to remove his attorney. So specifically, the murder occurred in this case in October in 2012. The first attorney to represent the defendant was Jamie Barkley of the Public Defender's Office. She was appointed in February of 2013. So it's important to know what she actually did and then what the defendant did to sabotage the relationship with her. She actually met with the defendant several times. The DA's office had an open file policy. She reviewed all of the file. She discussed the evidence at length with the defendant and initially exchanged several letters with him. She testified at the February 1st hearing that she was fully prepared to proceed to trial. And yet, the defendant wrote a letter to the trial court asking that she be removed, claiming that she had problems with her misrepresentation and insufficiency, is what he called it. He filed 2 complaints with the Tennessee Board of Professional Responsibility. And I point to the recent case of State v. Thigpen that was authored by Judge Dyer and joined by Judge McMullen, where this court referred to a previous case that says acts of violence, that these complaints against with the Tennessee Board of Professional Responsibility constitute acts of violence against the professional reputation of the attorneys. So even though they may be commonplace, they are no less egregious. She claimed.
Do we not have is there not a Board of Professional Responsibility general response to lawyers? Is they are not grounds to withdraw, aren't they?
The point is the efforts by the defendant to sabotage his relationship with his attorneys. And so in this complaint with the BPR, he unjustifiably claims that she was incompetent, that she met with him only once in a year. And that is not what happened. Those are just unjustified, untrue allegations.
Did he make any allegations about her sending him to investigators without her being present?
I don't know if I do not know if he included that in his complaint, but I will address that as well.
Okay.
So he filed a motion to remove her. And then when that was denied, he went so far as to appeal that denial to this court. This allegation that she witnessed a false coercion was another example of false false allegations that he made in an attempt to sabotage this relationship. What happened is this. There was a March 5th, the police met with the defendant on March 5th. This is detailed in issue number 2. The police met with the defendant. And at that point, he confessed. And the police officer brought up this question about the car that the defendant and his 2 co-defendants had driven to the home that they burglarized and where they murdered the victim. And at that time, the police officer didn't have a photograph of the car. They later obtained a photograph of the car. The police officer asked the defendant, if I obtain a photograph of that car, can I come back and have you identify it? And he said, yes. The police officer obtained the photograph of the car, called Miss Berkeley because she was representing the defendant, and said, could you please come with me to this meeting with your client because I'm going to show him a photograph of the car. Later, when the defendant started to make false allegations about the police officers coercing him in his confession and beating him up, etc., he claimed he just made a just nonsensical accusation that this was somehow some coerced confession that Ms. Berkeley had been a witness to. It just doesn't make any sense, but that's what they're referring to, and that's what defense counsel is referring to. It's an absurd and false allegation against Ms. Berkeley in order to sabotage their relationship.
Well, how did she get off the case?
Well, because after the trial court denied his motion to remove her, he refused to speak with her. He refused to speak with anybody from the public defender's office. She attempted to communicate with him to him in writing, but he refused to respond. She attempted to speak with him in person in prison. He refused to see her or her investigator. Meanwhile, he filed pro se motions. Finally, she filed a motion to withdraw, and she told the court everything that had happened, and she said he has already in fact de facto terminated the relationship. And then the defendant filed a second motion to remove her. He filed more pro se motions, and finally, a year and 2 months into their relationship, the trial court granted her motion to withdraw.
So let's just assume that the defendant intentionally did things to get Ms. Berkeley and was it Webb, I think, or is that the other lawyer?
Yes.
Okay, thank you. Removed from the case. What concerns me the most is the last lawyer and how that was handled. So you have a January hearing at which the lawyer is told, and the defendant is told, you're his lawyer. Get ready for trial in February. I'm not letting you off. You behave, quit bothering your lawyer, work with him, this, that, and the other. We're going to trial, and we're going to trial in a month. This is your lawyer. Okay, great. We then get to the day before trial. There's no proof in the record, as I understand it, that the defendant misbehaved during that month. And the only proof, as I understand it, is counsel said, I haven't spoken to him in a month. Why do you remove counsel at that point? And if you're going to remove counsel at that point, when the defendant has said, you haven't shown that the defendant's misbehaved and tried to screw the system up yet again, and I'm, again, let's just assume he was. That was his plan all along, but he didn't do it for the last 30 days. How do you withdraw counsel at that point, and how do you make him go to trial the very next day? When he did what he was told to do by you as a trial judge, but the trial attorney clearly did not do, at least based on my understanding from the briefs, what he was supposed to do for the past 30 days.
So 2 responses to that. About him misbehaving, it's true that he did not orchestrate any more threatening voicemails, But that's not the only form of misbehaving. At the January 11th hearing, on the very heels of the trial court saying, if you persist, you're very close to waiving your right to an attorney and explaining the risks of self-representation, he, on the very heels of that, persisted in making false allegations against his attorney, saying he wasn't doing his job, and that he said this, I'm ready to go, but Mr. Morris is not doing his job, and neither Mr. Webb nor Mr. Morris has reviewed any evidence.
Okay, but this is at the January hearing. He's telling the trial judge this?
On the very heels of the trial court saying, it's not just saying don't have another person call and threaten Mr. Morris's life. It is behave, let your attorney represent you.
Okay.
Within one page.
Well, I understand that, but that's all happening at the same time. And so my question is, so the defendant got it all out. He still continued to say things about his attorney, but it's all happening there. At the end of the day, at the end of that January hearing, he sends them off, he basically sends them off with this instruction: you behave and you get ready for trial. What did the defendant do after that instruction when he left the court in January, whatever the date is, between that and February 1st or 2nd, whatever that next date is? What did he do that caused the trial judge to say, you know what, I warned you 30 days ago, if you didn't behave, you're going to lose counsel? What did he do in those 30 days that caused him to lose counsel?
Yes, and two things happened at the February 1st hearing. 7 pages into the hearing, the defendant is continuing to signal to the court he's not going to work with the attorney. He says these words, no, I'm not going to work with him. So at the outset of the February 1st hearing, he's still saying, I'm not going to work with my attorney. But so that's one thing. And that is, it's not just threats that it constitutes this array of evidence that the trial court considered and brought out at the February 1st hearing. It's the continually sabotaging the relationships by absolutely refusing to work, as I've laid out with Ms. Berkeley, and I've got further evidence in my brief about his relationship and refusal to work with Mr. Webb and also with Mr. Morris, especially beginning in October, when it became clear to Mr. Morris that the defendant did not want him to be his attorney. Coincidentally, as the trial court in various hearings was making it clear that he was not going to postpone the February 2nd hearing. But more importantly, what happened at the February 2nd hearing is that evidence was brought in as to who made those voicemails. Because at the February 1st hearing, those voicemails were played for the court. But it was, at the January 11th hearing, those voicemails were played for the court. But it was not until February 1st that the TDOC investigator and the police officer came in and said that they could trace those voicemails to someone in prison who had since the fall at one point been the defendant's neighbor.
But you've already reprimanded him for those phone calls. You reprimanded him in January for those phone calls. I mean, as I read the briefs, that's my understanding of what he did in January was, you've got these phone calls, you've made these accusations against your attorney, you've done this, this, and this, and this. I'm done with you. You caused 2 other attorneys to withdraw from the case. You're giving Mr. Morris a hard time. I'm done with it. So he's been reprimanded, so to speak, for the phone calls. But then he's told, you have 30 days to get your act together and for your attorney to get ready for trial. And so all of that's been hashed out. We then get to the February hearing, and all he says, as I understand your argument now, all he says is, I'm not going to work with this guy. He being the defendant. I'm not going to work with him. Is that enough to immediately take counsel off the case and say you're going to trial tomorrow without an attorney? Because he did what the trial court asked him to do, behave. And trial counsel then says, according to the defendant, I'm prepared for case. I haven't done anything the past 30 days. Why are we punishing? I get he misbehaved. I get it. But when push came to shove, the judge said, you got 30 days to get your act together and you got 30 days to get ready for trial. The defendant at least appears to have done what the trial judge told him to do. The counsel did not.
There's two issues here. One is waiver. And with waiver, you, after you're warned to change your behavior and you don't,
Is the state really operating on waiver?
no, that's what I was going to say. Then you pay more attention to what happened after the warning.
Okay.
But with forfeiture, you look at the whole picture. You look at the whole picture.
And you think this record represents enough for forfeiture?
Well, it's what the trial court has determined. And if you look at the difference between what the three counsel actually did, and from the get-go, all of the defendant's behavior that would, that basically, as this court.
Can I just say one thing while you're looking for your case? When I think of forfeiture, I tend to think of the cases that involve actual violence to counsel, some physical interaction. I think of much more intentional behavior than what I see involved here. So the state can speak to that. Procedurally, all trial courts have to deal with difficult defendants. These are people who are, trying to defend their lives. They're in a system. They're not lawyers normally, so they don't know really what's going on. So you run the gamut of the type of behavior that you're going to get. So when you say, I'm not going to give you a fundamental constitutional right to a lawyer to guide you through the system, I think of just the most egregious conduct possible. And what I've seen on this record is that this individual he was difficult. He was difficult.
Well, I think of it as a different way, because I think with physical violence, it's easier to control that. So that if somebody has, for example, assaulted their attorney in court, you can shackle them or you can have them guarded. But it's so much more insidious. It's sort of when you orchestrate somebody else to make threats. And these were not subtle threats. This was, get off the case or I'm going to kill you. I'm outside your house. I can come in next time. I know your license plate number. I know who your girlfriend is. It's much more insidious. How do you prevent that? And actually, I was thinking about the parallel between some murders that are not subject to the to death penalty versus murder for hire. And the rationale there is that when you're getting somebody else to do something, it's so much more insidious. And I think that's what happened here, because the next attorney, how do you prevent these kinds of threats? And this person, these were not taken lightly. When Mr. Morris arrived at the hearing on February 1st, he had a police protection squad protecting his home. His daughter was no longer visiting him. And to say to the next attorney, well, we can prevent the defendant from doing X, Y, or Z, but we can't really control who he calls to issue threats. We don't know also whether that person who placed those calls is still in prison or not. It just gets so much more insidious and, in my mind, much more dangerous when the defendant will orchestrate other people to issue these threats. And another thing about what happened between January 11th and February 1st in terms of getting ready for trial, they might not have communicated with each other, but that in no way means that Mr. Morris wasn't ready for trial, because you can become ready for trial without making the final communications with your client. And Mr. Morris testified that he had already reviewed all the evidence, et cetera, and he was ready for trial. So we really don't know.
Right. And I don't disagree with you on that. I mean, I think It's very clear if you just read post-conviction cases where they say my attorney didn't visit with me enough, that, yes, an attorney can get ready for trial without sitting down every day with his client. I'm not disagreeing with you on that point. I guess it comes down to what Mr. Morris testified to at that February hearing, because the impression I'm getting is he said, I can try the case, but I don't want to. And again, assuming everything you said before January, the defendant did, and he did with bad intentions, just assuming that's all true. I guess what has me most concerned is in that 30-day window when he was told by the judge, if you don't behave, you're losing the attorney, he behaved, and the attorney is the one who then says, even best case scenario for you, says, I can try the case, but I don't want to. And why are we punishing the defendant for that statement? We should be questioning the lawyer for that statement.
The defendant came into the hearing on February 1st. He knew that this hearing was to determine whether he had waived or forfeited his right. And he said, I am not going to work with him. So he didn't suddenly he didn't have a come to Jesus moment during those 3 weeks off to say, okay, now I'm going to cooperate with my attorney.
Whereas his attorney didn't give him a chance to, did he?
But
His attorney didn't call him. He was complaining about the communication. His attorney didn't tell him what evidence was going to be. His attorney didn't tell him whether he was going to testify or not testify. The attorney just quit.
we don't know that the attorney quit, and we don't know why they didn't communicate. They each testified that they didn't communicate with each other, but we don't know why. But we do know that the defendant didn't come to the February 1st hearing and say, I tried to reach my attorney. I'm really ready to cooperate. He did not say that. He came to the February 1st hearing with the exact same attitude he'd had since he had been first appointed an attorney after the murder, and said, I'm not going to work with him. It is not until he was stripped of his right to attorney where he started to backpedal. And significantly, that's exactly what happened in Carruthers, and it wasn't persuasive. After Carruthers was, the court determined that he had forfeited his right, he filed multiple motions to be appointed an attorney. It's not unusual that they backpedal once they realize that they're, that
Does it make a difference? Most of the cases that I remember in this area of the law frown upon forfeiture during trial, forfeiting the right to counsel during trial. Does it make a difference that the trial court made its determination the day before trial?
I think in this case, no, because for a couple of reasons. The defendant knew from January 11th that this February 1st hearing was going to be about that. So he already had some foreknowledge that this was going to happen.
Well, let's assume that the defendant knew that, and the defendant wanted the opportunity, I think I read somewhere, to subpoena individuals. No?
That is, there's no, he said a lot of things to backpedal. There's no reason to think that, there's no reason to think that his attorney wasn't prepared for.
No, I'm assuming that he's going to forfeit his right to counsel, and he's got to proceed pro se.
This defendant has repeatedly done everything he can to delay his trial. So the fact that he would throw out another reason why he would want to continue the trial is not surprising. There's no evidence of who he would have subpoenaed or what.
The onus wouldn't be on the defendant. Would it not be on the trial court to protect the judicial process?
The trial
What
court.
I'm saying, I'm trying to be with you in terms of logically carrying this out to its logical conclusion, and that is the defendant, let's say, assume he did forfeit his right to counsel. Does he not have the right to a trial and all the things that procedurally a lawyer would have? A lawyer would be able to subpoena individuals, correct, in time to have the trial, correct? I'm getting to the point of a day is not enough.
It just would be ironic that the very thing that you could do to sabotage the relationship with your clients to the extent that you would forfeit your right with your lawyer, to forfeit your right to a lawyer would then lead you to continuances for you being able to prepare. It would just be, it's not required.
I
And-
understand you
yeah.
think it's a red herring, but procedurally, what do you do with those people who have to represent themselves? You just say, we're just going to convict you. It's over. It really doesn't matter. Effectively, that's what happened here. The trial was a day, right?
Well, that's why you go through the lengthy hearing and why it has to be egregious behavior. And in Carruthers, it was a death penalty case. And he represented himself in a death penalty case. He had elbow counsel originally, but before the case was tried, that elbow counsel was allowed to withdraw.
That issue was litigated heavily prior to trial, though, correct? I mean, I don't remember specifically how long before trial did he forfeit counsel?
Carruthers forfeited counsel just a few days before trial, but then as Judge Dyer pointed out, it was the state who had an issue with one of their witnesses, and the state asked for continuance. So I think it's like 4 months.
So will you, though, at least, I mean, I think Carruthers can lend some light on how we analyze this situation. But you have to concede that Carruthers' behavior was not really in the same ballpark as Mr. Toomes' behavior.
I don't see, I've read Carruthers and I don't see that it's not in the same ballpark. There were threats made, and there were threats made here. There was, I don't know that it has to, I do point this court to the Thigpen case where the behavior wasn't significantly different. And what the court found is that the behavior demonstrated that if another attorney had been appointed, the defendant would have manufactured reasons to force him to seek to withdraw. And that's just what would have happened here. That's at some point it becomes clear.
Did the trial court make that finding here?
The trial court made the findings that he had engaged in these behaviors to delay and fit the criteria for forfeiture.
But did the trial court make a finding that even if I remove Mr. Morris and appoint lawyer Y, you're going to somehow do something to that one, and then when I appoint lawyer X, you're going to somehow do something there? Did he make that finding, or did he just say, look, you've done enough and you've lost your right?
That's the finding he has to make, and implicit in that is that it would just go on indefinitely. I just want to very briefly mention a few things from the reply brief. One is the issue of standing is not quite, that's just not the legal construct that applies here. This issue comes before the court on motions to withdraw. As soon as the court has knowledge that there's these facts that he needs to look into, that's what brings the whole thing to a head. The defense asserts that he didn't get proper notice. He's entitled to notice, but he certainly got notice. In the January 11th hearing, it was specifically set for February 1st to discuss this issue. It's not the state's memorandum of law that began it all. So it doesn't matter who they served. They actually had to serve the defense counsel because the defendant was represented by him. So that's not an issue. Defense counsel says that his client should have been appointed elbow counsel, but Carruthers specifically says that that's not required because when elbow counsel and Carruthers was allowed to withdraw, that was an issue, and the court said, no, that's not necessary. Defense counsel also says that defendant should have been given counsel at the January 11th and February 1st hearings. That's not required either. And in fact, in the Holmes case from the Tennessee Supreme Court in 2010, they outlined the procedures that should happen. And they said, first, counsel should be allowed to withdraw. Then you have the hearing about forfeiture. They never required another counsel be appointed. And those procedures specifically anticipate that he wouldn't have another counsel.
Well, one of the saddest things about all of this is that once the trial court makes this determination without doing a lot more, is there's only one remedy. Let's do it again. If the trial judge guessed wrong, he guesses wrong for everybody. Because everybody loses if we do it again.
The trial court did not take this.
Is there any other remedy available?
Well,
If the trial court guesses wrong?
no, but it's not the only consideration is the next attorney who gets appointed.
Do you know how many trials in the state of Tennessee are done without counsel?
I don't know.
Going to be very few. It is frowned upon.
It's why the trial court had an extensive hearing on February 1st. He brought in all three counsel. He brought in evidence of who had orchestrated the voicemails. And also, he did allow, just speaking of that, he did allow the defendant to cross-examine every single witness. And he also asked, with every witness except Morris himself, he asked the defendant and Mr. Morris to cross-examine them. So he wasn't not represented at the February 1st hearing. Another point to make about whether he should have been given the rules of evidence, et cetera, is this defendant has filed many, upwards of 30 pro se motions. At one point, the trial court asked him where he learned this and complimented him on the quality of them. This is not this is somebody who had injected himself and taken advantage of the opportunity to, in essence, as Mrs. Berkeley said, de facto be his own lawyer. But finally, it's the consideration too of the next appointed attorney. And for all of us in the criminal justice system who do not want to pick the phone up and hear, "I'm going to kill you." These are the words that he had to hear. He had to hear them in a handful of phone calls. "I'm going to kill you. Get off my case. I'm going to kill you. I'm going to come into your house and kill you." One of the voicemails, you heard gunshot sounds.
Why didn't he take him off the case when that happened?
Well, it's the same thing with Carruthers, and that shows you how thoughtful the trial judge was, because the last...
Carruthers, there was more than one threat. I believe there were threats to the mothers of the children. They would pull up to the school in motorcycles, if I'm thinking correctly.
I honestly don't recall those exact, unless that's not in the opinion that I read.
Lawyers in criminal cases have withstood a lot of doggone threats, and so has the Attorney General's office. My father was one for 16 years. We received those threats every day. It's part of the job. It's a dirty part of it, but it's part of the job. And but anyway,
it's the trial court's well thought out and supported conclusion. And of course, it's subject to review, but it's the logical conclusion based on this particular defendant's persistent maltreatment of his lawyers, culminating in a threat to kill the last one. And with that, I'll just rest on the other two issues on my brief.
Thank you.
It should be noted that the trial court in Carruthers never found that he forfeited the right to counsel. It was this court. But no trial court in the Carruthers case ever said that they were going to have a trial in a capital case without a lawyer. This court intervened at the request of defense counsel, not the state. I submit the state did more than offer an advisory opinion to the trial court by filing a motion requesting that relief be granted and calling 5 or 6 witnesses in that hearing. But opposing counsel today very clearly articulates the catch-22 that Mr. Toomes is in. It's inappropriate behavior to actually file pro se motions, put things in the record about what he wants done. That's the lawyer's job, and you should cooperate. But then she turns around and says, well, he was his own lawyer. He should have filed all those subpoenas. How do you file subpoenas on the day of trial? No one serves subpoenas on the day of trial.
Was he represented at the motion for new trial by counsel, or did he do that pro se as
He
well?
was represented by a lawyer who happens to be standing in this courtroom and has never received a bar complaint from Mr. Toomes in 18 months.
How did you get on this case? Are you a retained or appointed?
I am appointed, and the people in Crockett County are very nice to me. And despite the fact that I attend their Christmas parties and always have lunch with my opponents in Crockett County, the record is very clear that they lost their patience in this case. And they lost their patience in a way that violated Mr. Toomes' right to a fair trial.
What proof, I'm not saying this necessarily changes, but as far as subpoenaing witnesses, what proof did you put on the motion for new trial that, hey, if he had understood subpoenaing witnesses, he was going to call A, B, or C, or whoever?
Mr. Toomes, in the trial, Mr. Toomes, to gain credibility with Mr. Toomes and communicate the way that needed to be done, I think there were 89 errors alleged in the motion for new trial. Most of them, even despite the challenges with counsel who was litigating the trial, would have been waived in this court. That was not one I chose to raise in this court, but Mr. Toomes named in the trial on the transcript people he wanted to call as witnesses.
Okay.
They said you should have subpoenaed them, although you weren't supposed to file pleadings apparently as the lawyer. I'm proud to be a lawyer from Memphis, and one of the reasons I'm most proud is that the right to counsel comes from a lawyer from Memphis. Abe Fortas was the person who argued Gideon at the Supreme Court. It is a crime in Memphis. There is no high school or the juvenile courthouse is not named after the person who invented juvenile court and constitutional rights applying to children. But in Tennessee, we must protect our legacy, that we give people the right to an attorney so that we have a fair trial. There is no rule, as counsel said, that even says we must give him a lawyer. That is an interpretation by a court of what it means to have a fair trial, of what it means to have dignity in a trial. And that did not happen in this case. I ask you all to find that the trial court was in error. Mr. Toomes did not forfeit his right to a lawyer. And he definitely did not waive it when he heeded the trial court's warning and did not misbehave in any way from January 11th to trial when he received that warning. I ask you all to reverse this conviction and remand it back to the Crockett Council.
Let me ask you one more question, Mr.
Yes, sir.
Ward. So let's say you prevail, we send it back for a new trial, and all of a sudden, despite the great relationship you have with Mr. Toomes, he acts up again, and you end up having to file a motion to withdraw for whatever reason. Is that enough for this trial judge to say, look, you did it this one time, you had another shot, you're done?
On the first day of law school, I learned to answer every question with an "it depends." And perhaps if I get into a fist fight with Mr. Toomes, because that's where Judge McMullen articulated, I think that's a pretty good place for the line. If he calls people and says, I saw your daughter in pink PJs and a blue toothbrush in her bedroom last night, and I will kill her like Mr. Carruthers did, maybe we get there. But that's not where we were in this case. And I certainly hope it doesn't come to that. But I will say that I've never done that in 15 years, and this revealed to me how much that can get off track. And I would find someone, a friend of mine, pro bono, whatever it takes, to be Mr. Toomes' lawyer if I ever make that argument against him.
And I guess my question is, does this serve as enough warning to him that he needs to behave from this point forward?
Perhaps. I mean, a life sentence. I don't know exactly the Thigpen case we're talking about. The only one I've seen from 2020 with two members of this panel involved an appeal of a contempt conviction. There's a big difference between 10 days in jail and life in prison. And that's what happened here. That's why it's so egregious that it got off the rails the day before trial. This is life in prison.
Thank you both for arguments well presented. We'll stand in recess until 2:45. Thank you.
Your Honor, may I say off the record that we have now developed, in terms of trying to mentor people, for appeal. This is the first time I've been here in a couple years without leaving with a mentee. And